Welcome back. So lots of action at the NCLT courts in the Go First case, and we're getting inputs from the courts. The latest sort of contention that's being argued is that Go Air seems to be saying that it's quite confident that the emergency arbitration award will be held up. And the airline is saying that the emergency arbitrator has directed for Pratt & Whitney to supply engines. NCLT is observing, this is by no way is this hearing over. NCLT is observing that if engine concerns are the worry and they have led to half of the fleet being grounded, then NCLT is asking that even the remaining aircraft run the risk of perhaps being grounded. So lots of arguments and points being placed before the court, even as we speak. That hearing is underway. Well, as the sort of legalese continues on this one, let's get some perspective going with someone who's been, of course, tracking the financial services landscape in India for many, many years. We have Abizer Diwanji of EY joining in. Abizer, I know I'm not going to sort of draw you into the exact legalities of this case, and, the hearing is underway even as we're speaking. But we had a sort of a broader question in trying to sort of jog our memory and understand the architecture of IBC, because this is a pretty interesting case. It's Section 10 under which they filed even before technically defaulting on their loans. There is an operational creditor default in terms of the lessors, in terms of some of the vendors, but no default with the banks as yet. So what happens in such a case? Can existing promoters make a strong case to hold on to the company? How does it work?
Just to refresh everybody's memory, there can be three cases under which IBC can happen. The first case is where a financial creditor, after default, can file under Section 7. There is an operational creditor who can file under Section 8. And there is a promoter himself who can file under Section 10. Now, even in all these sections, you can file only if there is a financial or a operational creditor default. So including Section 10, unless there is an operational creditor default, you cannot file for IBC. And there has been, as you rightly said, Surabhi, there has been an operational creditor default, though there has been no financial creditor default, so the banks could not file it. But the company on its own took the initiative of saying that let us put it through a bankruptcy protection process under IBC and then try and work out a resolution plan. That seems to be what they have done, given the problems that they've had with PW engines, etc., etc. I see they've taken that view and gone in for this. So legally, I think they have done a good job in terms of saying, let's have some protection. Also, another aspect which actually troubles most existing promoters of companies is that if there has been a default of more than a year, those promoters are debarred from bidding for their own companies. Now, because Go Air has, or its existing shareholders have not had a default in excess of a year, they are actually quite eligible for bidding for their companies, as long as we can reach a quick resolution process under the IBC.
Okay. Thanks for the clarification there, Abizer. And next point immediately is whether Go First can hope for some sort of relief. I think what the company is seeking, and that's what became quite apparent even in the interview with Shireen yesterday with the CEO, that they're hoping to get some sort of a moratorium, basically some refinancing, some arrangement where they can get a breather and they can, get the fleet back up in the air. If they get the engines from P&W, Pratt & Whitney, that, of course, being the other caveat.
Yeah, correct. So ideally, the objective of IBC, Surabhi, is clearly to revive a company first, if it is revivable. And I think what the promoters may be hoping for, or the management may be hoping for, is that we get a sustainable resolution plan in place with the existing management to be able to execute the transaction. However, just the if that's what they're seeking, just a moratorium, they could have actually got a moratorium even otherwise outside of IBC. Very frankly, IBC is a good way of doing it, but they could have even got it otherwise. I think what they're looking for is a comprehensive restructuring proposal, which makes sure that the operational viability of the company stays. And at some stage, they may come back and say that these are our liabilities, this is how we can service them over a period of time, this is how we can pay the operating creditors, this is how we will resolve the PW issue, etc., etc. So I think that they would have thought through a comprehensive plan and done this. This is pretty much like the regulation, which is not applicable to them, is we have a pre-pack resolution even under IBC. And under the pre-pack rules, an existing promoter can come and present its plan directly to the lenders and say, here's my plan, now let's take it through the IBC route and resolve it. However, that is not clearly applicable to large corporates because only applicable to SMEs until now, MSMEs. However, my view is that had they taken the constituents into confidence, the creditors into confidence, the lessors into confidence, the operation creditors into confidence, and say, this is the plan we have already worked out and this is the blueprint. Now let's take it through a section 10 and implement that blueprint. I think there would have been far more confidence in the system. So that seems to have not been done, though I'm not close to the facts.
Abizer, very quickly, when JET's resolution process commenced, all the operations were halted. In the case of Go First, do you think if it does get admitted, will they be able to continue operating?
So clearly, it's up to the resolution professional to be able to continue the operations. And of course, the biggest thing to continue the operations is that one, the engines need to work, and secondly, the cash needs to be there to run the business.
No, but at a smaller scale, they can operate, right?
If they can, they can. So I don't think IBC debars anybody from operating a business. But generally, what happens in a services business is that in an IBC process, you will find customers declining. You will find suppliers not servicing your plant well, your airlines well. And if there is a general safety concern, you will not be able to revive the airline. Unfortunately, that is the nature of a services organization. Customers would rather say, you and me would rather say, let me fly another airline, then I don't know what's going to happen to Go Air. Is it going to fly or not fly? Even if it flies, are the engines safe for me to travel? Many things.
Just want to point out, we have some pretty important statements from the court coming in. This is exactly on the issue of moratorium. And this is what NCLT is saying. I think we have the flashes on our screen as well. There is no provision under IBC for an interim moratorium. This is the court speaking. NCLT saying there is only provision for an absolute moratorium in case the NCLT admits the insolvency plea. So I think these are some facets we'll have to keep in mind as well to figure out if there's this temporary halt. I don't know if that's something they'll be able to get, Abizer.
No. So there is no, the courts are correct, of course. But so what the courts are trying to say is that, there is a provision that there is a moratorium, but this is not moratorium on operations. This is moratorium on anybody raising a claim. So if PW wants to claim some money, they can't. They'll have to wait till the insolvency process is over. If the banks want to claim any money, they can't until the insolvency proceedings are over. All they can claim is regular operating expenses. So actually, in a way, an absolute moratorium is possibly a good thing because all other payments stop. You only make subsistence payments which are critical to getting your operations off the ground.
Sure.
Okay. All right. We're out of time. Abizer, thank you very much for joining in. Go Air also tells NCLT when Jet entered insolvency, it had 100 aircrafts. By the time a resolution was left, it had only 11. So for airlines, the only asset is the aircraft. Interesting the way this is proceeding. We'll keep tracking it.